Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. My name is Haika Dinesha bin Zulkifli Hosni, number metric 1191609, and I'm from TLC2. Okay, I would like to answer the tutorial question. Number one is compare and contrast the operation of the adversary system with the operation of the inquisitorial system. Number two, what features of the inquisitorial system are currently used or can be used in the future to improve the adversary system? And the last one is discuss how at least three features of the adversary trial system that aim to provide a fair and unbiased hearing. For the question number one, the difference between adversarial and inquisitorial system. First one is, in an adversarial system, the role of lawyer is active, while in an inquisitorial system, the role of lawyer is passive. The difference, next difference is, in an adversarial system, previous decision by higher courts are binding on lower court, while in inquisitorial system, there is a little use of judicial precedent in inquisitorial system. That means judges are free to decide each case independently of previous decisions by applying the relevant statutes. And the last one, the adversarial system aims to get the truth through the open competition between the prosecution and the defense, while inquisitorial system is generally aimed to get the truth of the matter through extensive investigation and examination of all evidence. Next are similarities between adversarial and inquisitorial system. A similar feature that is shared by both the adversary and inquisitorial system is, first one, both methods rely on an impartial third party presiding over the case. This means that in both systems, the judge cannot show preference or bias towards any party. They must be independent and impartial to ensure that their decision-making ability is not impacted by prejudice. And the last one, another similarity shared between both methods is the rules that bind submission of evidence. In the adversary system, certain evidence is deemed inadmissible, such as hearsay, prior convictions, privileged information, and evidence that has not been legally obtained, such as those that require search warrants. In the inquisitorial system, a similar set of restrictions apply through, not as harshly. Next, the next question. The answer is the number one. The inquisitorial system eliminates the advantages of wealth within the justice system because the judge in the case have the option to question and investigate, just as law enforcement and the lawyers do during the proceedings. The next, during a case, are more likely to convict a defendant compared to those who do not experience this emotional reaction. With this system, there is another line of defense against this emotional decision-making process. The judge can help to determine the facts of a case so that decisions are based on logic instead of feelings. And the last one of the most unique aspects of the inquisitorial system is that each group that investigate an issue will work independently to achieve an outcome of truth. Although there can be cooperation amongst the various individuals working a case, they are separate teams working toward an outcome by themselves instead of together as a group. Some systems may require complete agreement in the outcome from all of the groups working a case before a case proceeds any further. Now, the last question, the answer is number 1. One of the feature of the adversary trial system that aim to provide a fair and unbiased hearing is role of the parties. The procedure are completely in the authority of the two adversarial parties, which is the plaintiff and the defendant. Based on Section 63 of Sharia Code Civil Procedure, Federal Territories Act 1998, it tells us that the plaintiff should provide the statement of claim to begin the proceeding, while in Section 64 in the same Act, stated that the defendant can serve the defense against the plaintiff. Answer number 2, rules of evidence and procedures in adversary system is a feature that provide a fair and unbiased hearing due to evidence and strict. Also, the parties have an equal opportunity to present their case. According to Section 120 Clause 1 of Sharia Code Civil Procedure, Federal Territories Act 1998, stated that except as otherwise permitted by the court, any party may attend one person or his peguam syar'i, but every party must be present at the hearing. And the last one is the role of the judge. The judge roles during the case are to control proceeding and ensure that rules of evidence and procedure are followed. That means the judge will decide what evidence is admissible and not, and what evidence is inadmissible, and therefore to be excluded from the trial. That's all from me. Thank you. Assalamualaikum warahmatullahi wabarakatuh.